is off for some reason.
Okay, but the other one was on, right?
Yeah.
Okay, so when someone's arrested, it's the police officer that will make that decision whether or not to just cite the person, to have the person appear in court, or if it's a higher bar, the police officer feels the person should be held overnight, incarcerated for whatever reason. They have to contact the judge.
That's correct.
And the judge will then determine whether or not the person is held in a correctional facility at that time for an arraignment or given a citation to show up in court.
The officer, that is correct. The officer has the first determination as to whether to cite someone and release them, or whether to seek conditions of release and continued detention. The officer will generally speak with the state's attorney in most counties. The state's attorney will let the officer know what conditions of release should be ordered or be requested. Conditions of release are conditions that are set forth to reasonably assure public safety as well as mitigate the risk of flight. One condition of release could be bail to mitigate the risk of flight. The sole constitutional basis for bail is to mitigate the risk of flight and assure someone's appearance at court. This is something that we read about in the papers, and you will see frequently, I'm sure, during this session about, well, bail needs to be imposed because that person is a danger. The law is that bail can only be imposed to make sure someone appears.
I'm hearing that you're live, but there's no sound.
It's back.
It's back.
For some reason, those lights were turned off.
I sound better when I do.
Carry on, sorry for the interruption.
No, that's fine. Was the other mic working at all?
Usually those mics are always on, and for some reason, they were shut off, but they are on now. So
Okay.
the audio is good.
Good.
And so what the judge would do is consider, is there a risk of flight? If there's a risk of flight, the judge may impose bail. There are also certain cases where a judge can hold someone without bail. There would be a case with life imprisonment, a case that involves a felony, a crime that includes an act of violence, and the judge concludes that the state would establish by clear and convincing evidence that no condition or combination of conditions will reasonably prevent that violence. That's also under our Constitution. And so a judge can hold someone without circumstances. And we'll talk in a bit also, but the Department of Corrections, if someone violates probation, they have the ability to arrest them without calling the judge. And then under certain circumstances, they can be held until the next day. But the judge makes that original determination as to whether there's going to be conditions, and if those conditions will include a hold without bail or bail. And you can have non-monetary conditions such as don't go to this business, don't have contact with that person, don't drink any alcohol, things like that. You can have those conditions and let's say $10,000 bail. You can also have those conditions and you can have no contact or other conditions and a hold without bail. So what happens is if the judge says we're holding this person without bail or we're imposing bail, unless the person has the bail at that moment, and usually they don't. So what happens is the officer takes them to the jail and the officer has the conditions. And at that moment, the officer turns over custody of them to the jail. If it's a bail case and the court has imposed bail, if an hour later, the bail bondsman or a family member or someone comes to bail the person out, the Department of Corrections serves as the facilitator. They take the bail and they bail the person out. If it's a hold without bail, that person doesn't go anywhere. Generally, the next business day, there is a hearing that the judge has scheduled, whether it's a hold without or a case with bail. The Department of Corrections will hold that person until they attend the hearing. Sometimes that hearing can be remote. Sometimes that hearing can be in person. Historically, those hearings, based upon a number of factors, have been, in the past several years, have been remote hearings. And if we do have transports, if we have counties where we're able to have the sheriffs transport someone, they would take that individual to the courthouse for their hearing. But they're checked out of the Department of Corrections at that time and they go. If it's a remote arraignment, the department does facilitate those arraignments. In some counties, in some jails, such as the Southern State in Springfield, the Windsor County Sheriff's Department and Windham County Sheriff will actually help out. And they will facilitate moving people, I understand. And so they help to address that. Facilitation can include making sure that the individual has an ability to contact legal counsel, but it doesn't provide paperwork. It doesn't provide signing things. It doesn't provide sending paper back to the court. And so you may have read or seen recently issues about remote hearings, and those are the types of things that we need to continue to look at when we are addressing this in the courts as to how we can try to get more hearings in person at this initial stage. Can we get the transports? Is there the ability to do that? How's that going to look? Are we going to be able to do it regionally? Because certainly you might not be able to get someone to every court. But if someone goes to court and they're continued to be held on bail, then they go back to jail. And so the jail will take them back. Now, I point this out about the assistance and such because I would be remiss if I didn't mention that DOC, like many other state agencies and state government, has the difficulty sometimes of finding full staff. And I know that DOC's position has been, well, we would really like to help out with remote, but we don't have the staffing to do that. And so the question is, what's the best way to do it? One thing that I have said, and this is for the DOC, and Isaac can jump up and go, I object, it's okay. But if DOC had one, let's say you give them a new employee in each jail, and that person was there to assist with, do what case managers used to do. Case managers used to make the phone calls for people. They used to give paperwork. They used to get stuff signed for the attorneys. It doesn't require attorneys to travel from down south up north. If you had one person with that task in each jail, and maybe they took over the remote hearings, they facilitated that, they did that. It would add, yes, 5 employees, but it would also provide an ability to make sure that DOC has someone dedicated and the ability to make sure that those regional arraignments and those other remote hearings that we need to keep the system moving forward to address the backlog and the other emergency issues, that it would help with that. And so that I'll leave that to DOC to move forward on, but I do think that it would help the Department of Corrections to be able to do that, because with attorneys, if you get paperwork exchanged, and this used to happen all the time, it can facilitate, okay, now we're going to do a remote hearing today because they just signed this plea agreement, everyone's on board, and that person under the terms of the agreement, and DOC is on board and the victim's on board, that this person's going to get released. So there is a benefit that can inure back to DOC, that there's a benefit for all to be able to have someone there who's able to do that. And if they're not doing that, DOC has an employee to help out in other areas. So that's why I think it's important for us to recognize that DOC is doing, from what I understand and from what I've seen, the best they can. But if we got them some more resources, I think they would be able to do a little bit more, and that would help the entire judicial system. That includes all stakeholders. The facilitation, DOC after the arraignment, once they have the paperwork done, after the arraignment, if DOC, the case is going to go forward, what can then happen is, okay, well, DOC, let's say, is holding someone on bail. They've been returned to the jail, or they haven't left because they're held on bail. What happens next? Well, obviously DOC is responsible for their security and safety, watching them in the jail. But what else happens with the courts? Well, we have home detention. Still not as robustly used as we've discussed. For those of you who are new in the committee, that will, I'm sure, be a topic this year that we will touch on, because it's been something this committee has been attentive to. But the numbers hover rather low on that. But
How many did we get today? 3? 4? This is someone who is detained. And instead of taking up a bed in a facility, if they are appropriate, they could be detained at home. But it would be upon recommendation of DOC to the court. And it's the court that would make that final decision.
8.
8?
Yeah, it's 8 today. It has. It's been in the single digits. But what happens is, and the next interaction with the courts and this individual may be a request by their counsel or the court or Department of Corrections to say, evaluate them for home detention. Then if they are approved for home detention, what that means is they're placed under the supervision of Department of Corrections under certain rules. There's paperwork that they sign, and then they're released. The bail is still in place, but the bail is essentially suspended while they're under this status of home detention. DOC provides the supervision.
I don't understand the word, the bail is still,
The bail is still in effect. In other words, the way the statutes are written, the legislature enacted a statute that said if you have if you have a bail amount that you cannot post, the court has the ability to keep that bail in place, but the Department of Corrections doesn't have to have you in the jail itself. The department can have a program called home detention. It's similar to a furlough, but the rules are that the department monitors you outside of the jail. Because there's bail imposed and home detention is a component of that bail, if you have someone come in and pay your bail, you're no longer on home detention. So it's not like a probation or other type of supervision. Bail stays in place. And if you violate the conditions of home detention, you go back to jail under bail.
And the reason we really put in this statute of home detention, which was 20 years ago, was to take the pressure off of DOC in their beds from holding people as detainees if they were suitable to be housed at home with supervision. So it frees up a bed and there's cost savings there.
Yeah.
Joe?
Is home detention strictly a pre-sentence legal status, or may it exist or something akin to it post-sentencing?
It's pre-sentence. There was home confinement previously, and that was we'll say the equivalent of part of the sentence, but that's not there anymore.
Wasn't used. So we repealed it. Mary?
So this all sounds great, but what if the person who's incarcerated or being held, however they're being held, continues to not show up for their court case?
Well, if they're in jail, they will either be taken to court by the sheriff or they will appear remotely, so that we're good with them for appearing. If they're not in jail and they're on home detention and they don't show up, the Department of Corrections will generally pick them up right away and address that as part of the home detention component.
It's a violation of home detention as well. And they
I understand that, but that's not what we hear is going on in our communities.
I think what we're hearing more so of what we're hearing in our communities is that people have been charged, released on conditions with a future court date, and they don't show up at that court date. So they're not under home detention.
Not only once, but twice and 10
Right.
times and going on and on and on.
On and on and on. So there's lots of warrants out there.
With that issue, when someone doesn't appear, the court has to consider whether bail is necessary at that point or other conditions to make sure they're going to show up in the future. And that's a case-by-case analysis. And the legislature, with some of the changes last year that went into effect on July 1st, there used to be a $200 limit on expungible offenses. What happened was the legislature said, well, if you're on conditions of release already and you violate conditions and you have a new crime, that $200 is gone. And so it can be a higher number. And so that is something that theoretically can address that. If the court finds that someone repeatedly fails to appear, the court can order bail in an amount that would be reasonable to mitigate the risk of flight and to assure their appearance.
I wish it worked as easy as that.
So one of the other areas that the courts and DOC intersect are what's called pre-sentence investigations. There are statutes that provide that in certain types of cases, the department is required to prepare a pre-sentence investigation. There's also times that the parties can ask the department to prepare a pre-sentence investigation that may not otherwise be required, and the department does that. DOC, whether they prepare a pre-sentence investigation or not, generally is given notice of the sentencing hearing, and they will appear at the sentencing hearings. If they prepare the PSI, they are generally always somebody's there as the author or their representative. If it's a sentencing that doesn't have a PSI, generally DOC can be notified to be there. There are times where the parties resolve a case and it's sentenced and it moves on without DOC, and the first notice DOC would get of it is when the person is either put into their custody in a to-serve sentence and taken by the sheriffs, or it walks over with the paperwork at the court from probation to say, I'm signing up. What's critical also post arraignment is DOC is available as a resource to the court and the parties to provide recommendations or information. This, I would note, is different than providing a pre-sentence investigation. DOC employees in courts all throughout the state can tell you what the treatment type programs are that are available. If you do X for a sentence, here's what the structure will look like. Here's how those other convictions will be and sentences will interplay with the current ones. Here's some judge, they want to go to this residence. DOC will sometimes be able to say, oh, I know that residence, or I know this person, I know what's going on, and provide information there. They can also give information to the court and the parties, even outside the PSI, as to what some recommended conditions of supervision may be. If this person is going to come into our custody, here's the type of conditions we think we would need to be able to assist them in leading a law-abiding life. In some counties, DOC, as a matter of practice, has a representative sitting at court basically all day. And whether they have anything in there or not, they have people who are there. That is something that the judges will tell you is very, very helpful. You don't know you need them sometimes until you do. And having them there, it is very beneficial. I know in Windham County and some other counties, this is something that is there. If they're, when I was in Rutland, my last time through there, they were generally there. And if there was nobody sitting in court and you had a question, they would come over. And so that's an interaction that it might not be under the statutes or rules, but it's a valuable one. And it's one that they do every day and the court works with them. When the court imposes a sentence, whether it's an in-person sentence or a supervised sentence on probation, DOC supervises them. If there are persons on probation in the community, DOC is the entity that supervises them. If they're sentenced to a 2-serve sentence, DOC supervises them within the facility and they are released potentially on their furlough as to under the rules that govern furloughs by the department. DOC is responsible for the programming and treatment decisions. We don't come back to court. The court will say, here's what the sentence is. But if it's a 2-serve sentence, the judge doesn't reach in and say, here's the programs that person takes. That is solely up to DOC at that time. If it's a probationary sentence, the judge will set conditions of probation because the person is not in custody for purposes of a 2-serve sentence, and the judge will set the conditions then. But DOC is responsible for the boots on the ground, working on what's going to happen with those programs. Where's it going to take place? How are we going to arrange it? How are they doing in the programs? If there's a violation of the conditions, if someone is not doing what they're supposed to be in their programs or not appearing as they're supposed to with their probation officer or other violations of the law, the department has the ability to file a violation of probation with the court. DOC has the ability to, under the statutes, to arrest that individual. And then DOC would bring that person to court and we would have DOC there with us in the court on any hearings related to that violation and upfront whether or not the person is going to be released or held, and any violation and any determinations as to what's going to happen as far as a disposition if we got to that, if the state establishes that there's a violation.
I just want people to be very clear here when the judge talked about probation. Probation is under the courts. It's not under DOC. Probation is under the courts. And it's the courts who set the conditions that the person has to abide by while they're out in the community on probation. It is DOC staff within our field offices across the state that will supervise that person that's on probation to make sure they are meeting those conditions that the court has set. If a probation parole officer finds that there is a violation of one of those conditions, they bring the person back, could be held in a correctional facility overnight, but the person has to answer to the court. It is up to the court that will then determine, does the person continue on probation and change some of the conditions? Or you could send them to a correctional facility.
Could revoke the conditions of term of probation and impose the underlying sentence or a part of the underlying sentence. You could, if it's a 2 to 5 year sentence and they had never had to serve a day in jail, you could say, okay, it's going to be 2 to 5, all suspended, but 60 days and have a 60 days sentence. You have the ability to structure things like that.
So people will use probation and parole interchangeably. They're two separate, completely different things. People can use probation and furlough together, two separate things. So it's really important for probation for people to understand because it's with the courts. The courts make that decision. They set the conditions. If there's violations of the conditions, it's the court that decides what happens to that person. The supervision is done in the community by our correctional employees, our field officers out there. But they don't set the conditions and DOC doesn't decide whether or not that person continues to be on probation or is incarcerated. I just want this little block to be really clear with folks because we need to understand the different statuses. Questions? Make sense?
Another area for detained individuals that DOC and the courts interact with and intersect is on remote proceedings. Even if it's not the criminal case that they're there on, DOC will assist oftentimes in facilitating in other types of hearings. They can be telephone calls for some. I know that DOC has, in the criminal case, they'll oftentimes, they schedule the remote hearings and they're getting competition from all over the state. So it's not as though that we have 20 rooms where everyone can go in and have a hearing at the same time. No. You have basically one spot or a couple spots in the facility where they can have a hearing, and DOC facilitates that to make sure that we can schedule that and have things go forward. Sometimes there's emergencies come up or other things come up that make that more difficult, but DOC is responsible for helping assess how the types of cases that we can do that. DOC has standard operating procedures that says we'll allow you remote hearings on certain types of cases. In other cases, we're not going to facilitate them. And so we work with them on that. That's another reason why my suggestion about if they had more people who are focused on this, I think we'd be able to expand the areas and allow more hearings because you'd have someone who is dedicated to scheduling them, facilitating them. The day-to-day interactions are something that takes place in all around the state. We get emails from the Department of Corrections to the criminal divisions telling us who they have from the night before or the weekend before, who needs to be seen in a lodging block because they're held on bail, extradition, arrest warrant, whatever the reason may be. And so we get those first thing in the morning. The court also deals with DOC on a daily basis because if someone is picked up and they do come to court and they're going to be released, the court is responsible for letting DOC know what conditions are. As far as whether they're going to be released after the arraignment, whether they're staying in jail, the court sends that paperwork on to DOC, so DOC is aware. So there's paperwork going back and forth. We have, in order to set up hearings, the court has to go through what's called the alias, and they send in saying, we have hearings on this date, we'd like to have what's available. So DOC has people right now who are working to make sure that we schedule hearings and get them on the calendar. We have certain other types of hearings. They'll do that for TPR, termination of parental rights. DOC did agree that even though that was not originally one of the types of cases it would facilitate remote WebEx hearings for, it's now agreed that if it's a termination of parental rights hearing, it would facilitate having a parent appear that way. We also have been able to, there were some CHINS related funds that we were able to utilize that we are now paying sheriffs to transport because that's not part of the criminal transport deputies. So we were paying sheriffs to transport parents to TPR hearings, but DOC did allow that. And that was an expansion from where they previously thought they could allow these types of WebEx remote hearings. If there's other types of hearings, DOC also, a year ago, I couldn't have said this, but DOC has gone and said, okay, there's attorney phone lines that come into the jails. We'll let you use the attorney phone lines. We might not be in a position to have you utilize the WebEx because it's being used, but we can have you utilize the phone lines and it can be an audio hearing. The individual can call in for the audio participation. And depending on the type of hearing, if it's a quick status, that may be perfectly fitting for it. If it's an evidentiary hearing, certainly that's not as good as a remote hearing or in person. But DOC did take that step basically to show, in my assessment, that they're trying to help us where they can with the resource limitations that they have. DOC's.
So for the WebEx hearing, it's not a hearing, that's WebEx. WebEx is like Teams, it's like Zoom. The courts use WebEx. They don't use Zoom, like the legislative branch uses Zoom. The executive branch uses Teams. Judicial branch uses WebEx. So when he refers to the WebEx hearing, it's done electronically.
It's the platform.
It's a platform.
It's let's say Zoom.
It's a Zoom.
Keep that thought. Zoom. I like that. Zoom is a platform that's used in most courts now, so we'll see. DOC, again, with bail and day-to-day interactions, if someone shows up at the door and says, oh, I have bail to bail somebody out, DOC is responsible for taking the bail, and they will take care of that. If someone posts bail at the courthouse, the court has an interaction with DOC. DOC is notified every time there's a prisoner case that's filed. When I say a prisoner case, there can be, in the civil division, someone can file a petition for a writ of habeas corpus saying that they're unlawfully detained. Someone can file a post-conviction relief case, which says that there was something wrong essentially with their case, and there was a defect such that they should not be sentenced and they should not be found guilty. They should not be held anymore, and that the conviction should go away. When that comes in, DOC is notified of those cases, so they're aware of what's going on. There's also appeals that will come to the civil division if the Department of Corrections has a furlough and they revoke the furlough. That individual does have the ability, after going through the administrative procedures in the jail, to file an appeal with the civil division. And the legislature a few years ago worked on those statutes as far as the appeals go and what they look like for revocation of furloughs. There's also, when you have litigants in jail who have relief from abuse cases and some other type of civil cases, even though it's not something that can always be guaranteed, oftentimes the caseworkers in the jails will try to do what they can to help out with their other limitations and their other duties. They do try to help out on those types of day-to-day interactions. There's an interest of justice hearing, and that's when you have a youth under Vermont law who is going to be held in jail. There's a requirement that what's called an interest of justice hearing be held, because that individual has to be held outside of sight and sound of adult inmates under federal law. And so DOC will let us know if they have someone coming in that qualifies for that. We send paperwork electronically, the courts to DOC, DOC to the courts. We give them the sentence information. They send us sentence computations. It goes back and forth on a daily basis between the courts. As the chief superior judge, I meet regularly with our trial court operations. A woman named Lori Canty is a name you may have heard in the past. And if you haven't, you'll hear it, I'm sure, in the future. Lori is responsible for taking care of basically, if there's data requests or everything, she knows how to get it done. She was a court clerk in Rutland forever. She has forgotten more about the judicial system than most people know. And so Lori and myself, we meet with a number of representatives from the Department of Corrections, the State's Attorney's Office, and the Defender General. We have regular meetings scheduled on an ongoing basis to make sure that we stay on top of things, to try to discuss the issues, to see if we can come up with solutions on areas. If something has happened that is concerning, or if something has happened that we think shouldn't be happening, we can be in contact and convene earlier and have discussions. I will also meet Commissioner Demmel and his executive team are very accommodating to visit. If they have an issue that's come up, they'll reach out to me. I can reach out to them. The court administrator, Terry Corsones, is involved in that oftentimes. And so we can work together and do often have conversations to try to come up with solutions to the issues that arise. You can wake up on a Monday morning and think your week looks a certain way. And by 9 a.m. that day, you're on the phone with Commissioner Demmel or someone from the staff, or trying to figure out, okay, something's not going right. And we try to make sure that we address those issues. We get the daily population counts. from Department of Corrections. Jordan Pasha sends out an email every morning that we all get. There you Jordan, thank you. I saw you here. My wife will say to me some days, well, who was that early morning email from? Jordan. And Jordan, I'm sorry about this, but my day isn't complete until I get that email. It's like, okay, I can't start.
What
Come
time
on.
does it come through? 5 o'clock, 6 o'clock in the morning?
Usually by 6:30.
Yeah, it's really, I'm waiting for it. Very excited.
Jordan is like, oh, I gotta do this again.
Half the day's gone by 6:30.
That's what I'm going. Jordan, where you at? He's compiling it and it's so well done. But they provide us with that. If I have questions, I see, Josh Rutherford, also, I will email Josh. How many times have I emailed Josh or Isaac saying, I have a question about certain data? They email back. Those are intersections. Those are daily interactions that we have. They also assist with new judge training. We have 4 new judges. One of the components of the training is to make sure that they understand what the Department of Corrections does and how it does things. So just last week, we had the new judges meet with Department of Corrections. Josh and I think Gary Marvel was going to try to be there too. We also had the new judges tour the Chittenden Regional Correctional Facility to give them that experience, and DOC facilitated that. So each of the steps that we have with judges and staff, we understand and recognize the importance of working with DOC. And it's something that, again, we do it every day. Do we always agree? No. Are there things that I would say, here's what you should do? Sure. And are there things that they would say, Judge Zone, here's what the judiciary should do? Yes. But I think it's important to note that it is a relationship of intersections that people listen and try to find solutions. The goal is not to just go into your corners and say my way or the highway. It's okay, what can we do together to try to make something work? And it seems to be a situation that a number of times we've had difficult circumstances that we've been very fortunate that DOC's willingness to work with us in the judiciary in a number of different areas has proven beneficial. And that's not just beneficial to the court, it's beneficial to the stakeholders, and in the end, the individuals who find themselves within the Department of Corrections custody and for public safety.
Thank you. Questions? Connor?
Yeah, Judge, thanks so much. It's even being on here at Biennium. I learned a lot in that short presentation, so appreciate that. Like the biggest intersection I see to some extent, and it's something we deal with every day, is just 40% of the incarcerated population being detentioners, right? And I think that's challenging for us, right? Because as we look to sort of chart the future of the system, you wonder, do you plan for what it's like today, or do you try to be aspirational and plan for what you would like it to be, right? And I think that's something we struggle on this committee a lot. So I'd appreciate your thoughts on that. And then the other, quick, this is so simplistic, it can't be right, but why aren't we just hiring a ton of public defenders and prosecutors to get this backlog under control when the average cost is over $80,000 to incarcerate somebody? Feels like it would fix itself pretty quick, or at least put a dent in it.
Well, certainly, I don't see Tim Lueders-Dumont here or Matt Valerio, but I'm sure they would say that if there was the ability to hire additional individuals, that would certainly be helpful to address the backlog. The legislature over the past several years has addressed court needs with additional staffing. And we now have 4 more judge positions than when I took this current position in the fall of 2021. And so those new judges will be on board in February. They're in orientation training right now. In going forward, we think that's going to help with the backlog. But the questions about how many attorneys, there's also the question of can they find them? And so if we said you get 10 more public defenders or 10 more prosecutors, the question is, are they going to actually have 10 individuals in each of those slots to be able to hire? I think that's one of the challenges that's out there. But certainly if we had more prosecutors and more defense attorneys, and there has to be balance. The 3-legged stool, if you cut one of the legs down, it doesn't sit right. And so if you added only prosecutors and no defense attorneys, no public defenders, that's not going to work right. You need the balance there. And so that's, would that help? Yes. When you talk about the detainee population, if I can
See,
there again,
I could just stop right there. It would help to bring more. folks in on the defense side as well as the prosecution side, but it's gonna cost more.
Mhm.
And that would increase our general fund. And there's always this balance that we have in this building. Do we hire more folks to do what we want? We're gonna have to pay. We're gonna have to find the money within our budget, within our general fund budget, pay for it. Because the state pays for your defense counsel and they pay for your state prosecution. It's our nickel that pays for it.
I apologize, this isn't quite as big as I'd like it to be, but here is what I have. You ask about detainees. That chart doesn't want to look great. This chart is one that I developed. This is my chart. Come on, there we go. It's 2019, 2020, 2021, 22, 23, and 24. This is only current until November. I actually have a new revision coming out tomorrow. See, that's a day late. I'm sorry. But if you look at this chart, what this tells you is the number of detainees. Years ago, back in 2021, look where that number was, the gray. See how low that was? And the chart, as far as the numerical numbers, it's to the left. You can see what they were at each time. I remember it was a push, if you will, for people saying we need to get rid of pretrial detainees. We have too many.
Mhm.
The numbers have grown. If you look at 2024, it was trending pretty high. We went from down in the lows of under 300 for a period of time. And now we have been trending in the past 2 years. We are up in the 350 and over. Today, that number, 510.
510.
I believe, am I correct, Ruth? I think it was,
Yeah.
How many of those are
Yeah,
federal detainees?
No, that's state.
That's just-
that's state, that's just state. No, that is just, these numbers are not federal detainees. I separate those out. This is just, we have this many people.
And
So today there's 510. It's long weekend
on weekend.
and the morning. So I will bet you by 5 o'clock tonight, a number of those individuals will be released. So the number won't stay up that high. But what do we see? We see it's trending higher. I think on July 1st, I think the number was 468. And why is that number somewhat significant is because that's the date that the new law went into effect, getting rid of the $200 bail, allowing a higher amount of bail. And so some may ask, well, is that having a difference? I can't tell you that accounts for everything, but I can say that I am aware there are cases that people have had bail imposed in an amount that could not have been imposed prior to July 1, and they're still detained. In other words, there are people in jail who that law definitely has detained when prior to that, they wouldn't have been detained, I believe.
What's the cap? What's a new cap on that bail?
There's not.
It was a cap.
Do you know
was-
what the highest is?
I don't
currently?
have that in front of me.
We took, Judiciary Committee took the cap off.
I don't,
I didn't know if they put a new one in.
no, there's no new cap, and it's difficult to tell because you'd have to go in and start looking at the cases. So you'd have to go in theoretically and look at every case to see, okay, for instance, if this is a simple assault, a misdemeanor that's expungible, and they had $1,000 bail, you know that would have been outside the cap because otherwise it would have been 200. But you'd have to go in and look at it individually.
But beyond that, it looks like, I don't know, maybe from 1 August of 22, that there's a pronounced uptick prior to the bail reform of
Mhm.
July 1st of last year. Whereby there's only one number below 400 prior to that, and that's all there is. Only one under 400 after. So is there some kind of
Coming out of
change in that?
COVID. We were coming out of COVID. During those earlier periods, I think it's safe to say that there was less law enforcement activity on the roads. There was less individuals coming to court. There was those efforts in all, whether it's state or federal. There was efforts to say, okay, we don't want to have people in jail all the time. And so I think that it was a function of the number of cases coming in, requests by prosecutors, and decisions by judges.
Thank you.
And the courts were closed.
And 22 was, again, that's when we were coming out. And so that was, we'll call it that was getting us back to, okay, what the real world is again. And you're having the judges make the decisions based upon, it wasn't the pandemic in the jails at that time.
So that's, we've always struggled with the detainee population because we have, I hate to say 1,400 people incarcerated. And 950 are sentenced of that. And it's really expensive to hold detainees, but people want people held. They don't want them released. They want them held. And the way our system is set up, for better or for worse, in our facilities, detainees and sentenced population are housed together, which is not always the healthiest situation for that.
Today's total population, it says, is 1482.
I heard the words, but I didn't understand what you said.
Okay,
Who is in the 1482 that's not 510, the detainees?
sentenced,
Say again?
sentenced, folks who
Sentenced.
have a sentence.
Just
Yes.
sentenced, they have not, okay.
They're serving a term, they've gone through the courts, they've had a sentence. They're serving a sentence, so you've got those folks there, and then you've got another. Basically, it's a third of your population is detainees, they haven't been sentenced. And to mix those two populations is not the healthiest for a system.
And one of the things that we are striving to do is to address the backlog too, is to move the cases faster at a more, at a level that's going to allow us to not have someone be in jail for 6, 9, whatever it may be, months, but we need to get the cases taken care of sooner. And that is something that's beneficial for everyone. And with the new judges, our goal and our hope is that's going to happen.
So, okay, Troy.
Because we've talked about this before, what's the current rate of resolution of those cases versus the current rate of new cases? Are you getting ahead of it?
Yes, I could get a county by county, but we're over 100% for our reduction for what's called the clearance rate. Clearance rate is if you have 100 cases coming in and you settle 100 cases, you have a 100% clearance rate. You're right on target. If you settle 95, you have a 95%. So our goal is to have that number up. Some courts, for instance, the environmental division, I think, has a clearance rate for the past year of over 160%. Good. And so we also have, in the criminal division, it was over 100% also. And it goes up and down.
Yeah.
Some months, if you have jury draw and you have enough days, you can have a county where it's 200%. It can be with not a lot of cases coming in, but you resolve a lot of cases. And then sometimes you don't resolve a lot.
Haven't you projected the timeline as to how long it's going to take to get to?
We haven't projected any specific time. There are some who have said, oh, it'll take us X, Y, or Z. I haven't taken that step to say, here's where it is. Our goal is to take care of it as soon as we can. And yeah, do I have ideas when I'd like to see it? Yes. But no real firm projection.
Gotcha.
So when you're looking to sentence someone, does the availability of a bed in DOC play into that or not?
I cannot say that is one of the factors that a court is looking at. You have a number of factors that the judge has to look at. It's not one of the enumerated factors, the availability of beds or how much it's going to cost to house someone. Are judges aware of those things? Sure. Judges certainly would be aware of that, but it's not a factor that the court is to look at. Is it something that can be considered and tie into a factor? If a judge is looking at it and thinking, okay, this person needs correctional treatment, I think that, boy, it's a close call. They might be able to get it in the community, but I think it might be better in the jail. And then the judge hears, well, there's no beds in the jail. Can that affect the judge's decision? Sure, because the judge would say, okay, what I'm trying to effectuate here, I've just been told can't happen. And so in that way, yes, it is something that can be considered, but it's not, you don't start out and say, oh, the jails are pretty crowded. We can only put 8 people in jail this week or something like that. We don't look at it like that. But are there specific factors involving a sentence that it could play into? I think yes.
Well, that also leads to the next question, because I got a couple questions. I wrote them down so I don't forget them. So there's always been thoughts if we could provide more programming within our facilities to really help folks who have served time there. When they come out in the community, they're in better shape. They've addressed their issues. So if we provide the programming that would be needed, it could be substance use disorder, it could be mental health, it could be domestic violence, it could be a variety of things. We've heard over the years, over and over again, that if those are provided, those programs are provided in depth in corrections in a facility, the tendency would be that a lot of these programs are not available out in the community or they are full, that there'd be more people sentenced to an incarcerated setting because then they could access that program. That's always been an argument that has played out in this building for years. And if DOC provided more program, would there be an increase of folks being sentenced because they could access that programming in an incarcerated setting because it's not available in the general community?
I can't say that there would or wouldn't be an increase. Are there cases that when the judge looks at an individualized sentence, that he or she may determine that because there is a program, that that individual in that case is going to go to jail? Yes, that is something something a judge has to consider. Where can they get the treatment most effectively? Where can they get the treatment most safely for themselves and the community? And so is that something that could be considered by a judge? Yes. Judges also keep in mind, though, that, and I've said this, I don't sentence to program because if I am sitting here today and I say, I am sentencing you to jail for 2 to 6 years because DOC has the ABC program that's going to be great for you, and 1 month down the road, DOC cancels the ABC program, what have we accomplished? And so that's the difficulty of sentencing to a program, and that has happened. I've had cases where you've sentenced someone and they believed I sentenced them to a program, and I didn't actually in that case. I said, no, this is the jail sentence. And there was a request saying, well, if you knew this program wasn't going to be there, would you have given the same sentence? And the answer in that particular case was yes. But it did highlight the fact that it's possible that in some cases a judge would say no. And so that's the difficulty of sentencing to a program, because there may not be a program down the road. And that does happen as DOC have to change programs, what if they lose a provider and they can't deliver it? And you've put someone in an environment solely for that, and they don't get it. That's not appropriate.
Then my other question, for folks who are detained, they're waiting to go to court. They're waiting for a sentence, and they could go to court and they could have a jury trial or not. So of cases that are out there, how many of them really do go to trial? How many of them really do go to court before they're settled?
99, it was 1 year was 99.69, I think, and 99.57 was the next year. Over 99% of the cases generally resolved by plea agreement or dismissal. And plea agreements will oftentimes be part of a dismissal. So the vast majority of cases never see a trial.
And those plea agreements could be agreeing to a lower charge.
Those plea agreements absolutely, and often do. They have a negotiation of charges as well as oftentimes a resolution of the eventual sentence. There can be a plea agreement where the state says, you're charged with aggravated domestic assault. We're going to amend the charge to a misdemeanor domestic assault, and here's the probationary sentence. That's something that can often happen. That's up to the state and the defense whether they agree to that. Then the question for the judge is whether the judge will impose that sentence and agree and accept that. The question is not whether is that the amendment the judge would give, or is that the sentence the judge would give if there was a contested sentencing, but rather whether that particular sentence is one that falls in the acceptable range on the charge the state is moving forward on. Not on the charge that was dismissed, but on the charge that the state is seeking a conviction on.
And the parties that need to agree to that is the prosecution, the defense. Also, the defense would be there for the offender for the defendant, as well as the victims. Everyone has to be in agreement in that plea agreement.
Well, not always the victim. There can be times where the state and the defense come to an agreement, and the state will say that, Your Honor, we understand that the victim does not support this agreement, and they're here today. And then they can tell the court will listen to why the state thinks it's an appropriate resolution. The defense can say why it's an appropriate resolution, and the victim can certainly say why they think it's not. There are cases where the court will say, okay, thank you, we've heard from everyone, and the court, after listening to all of the input, concludes that the sentence is one that falls within an acceptable range, and recognizing that the victim is not on board. There are cases where the court may say, and I've done it, where the court will say that I've listened to everything and not accepting this. The court will not accept this agreement, and I've rejected plea agreements.
And what's the frequency by which somebody is detained longer than their eventual minimum sentence?
I don't have a statistic on that.
That happened?
Generally, it does not, but I know that there have been times where it's been come up, you go, wait a minute, that person has been there.
Yeah.
So the attorney or someone would generally, that's something that would generally come up and be resolved.
Okay.
And that kind of leads in, when a person's a detainee, for every day served, it gets calculated as credit for time served. So if they've served for 2 years as a detainee before they've gone back to court for their sentence, and say their minimum is 5 years, they've already served 2 of those 5 years. That's how it plays. And you may not have an answer to this, but do you think some folks are not paying bail purposely so that they can stay as a detainee and have those days counted?
I could not be in a position to
That's
say that. That's certainly others may have views on that, but I wouldn't be in a position. And again, as far as the individuals, I can remember cases where someone would say they're maxing out, and then it came to the attention of the court. I'm trying to think if there's times where I can remember someone saying, well, they've served more. I think it's generally brought to our attention before they get to that, but I can't say that it's never happened.
Sure.
I can't think of it happening
Yeah.
because usually it's flagged.
questions? Other,
Yes, I have to.
Kevin?
I'm sorry.
No, that's fine. That's why we're doing it.
Non-lawyer, everything you described sounds very reasonable. In fact, the fact that there's no maximum bail and it's up to the judge to determine whether the individual, the offender, should be held on higher bail for the safety of the citizens, that all sounds good. You're making progress in the backlog, and we're gonna have 4 more judges coming on board. That all sounds good. How can there be a perception of catch and release from the general population and our governor, who's saying we got to fix this problem? There's a disconnect. What I heard you describe sounds wonderful. We got a problem, but it isn't catch and release.
I don't think it's appropriate for me to characterize why the governor or the citizens may feel a certain way.
Forgive me.
No, I don't know. But what I can say is, when I describe what the process is, we have to look at every case. We have to follow the law as it's currently written. The purpose of bail is to mitigate the risk of flight from prosecution. Bail cannot be used to hold someone. There's oftentimes a misunderstanding of that in the public. I know years ago, Justice Carroll wrote an article in the Brattleboro Reformer before she was on the Supreme Court that talked about bail and how it can be and when you can and when you can't hold individuals. Our Constitution is not the same as the Constitution in some other states. And so people sometimes will say, well, geez, they do it this way in this state. Ours is different. And so I can't explain why others feel the way they do. All I can say is that our system is that we have to take the cases, and if someone comes before us and they have continued to commit certain misdemeanors, let's say, and the court can't find that they're a risk of flight, you can't impose bail. You cannot impose bail just because someone keeps doing something that is a violation of the law. If you keep trespassing into Walmart, you can't impose bail saying, well, you did it 5 times in a row, because the sole legitimate purpose of bail is to mitigate the risk of flight and assure that someone appears. If you get to the point where you say, I don't think you're going to show up again, then you can impose bail. And so that is what you do see happen, though. There are times where someone may not show up for court and a judge once will say, okay, I understand you made a mistake, but if that's a pattern, then you will see the courts oftentimes say, okay, we need some bail. But then people can post the bail. And so that's the purpose is, okay, are they going to show up? Because that's solely what it's for.
But just to make sure I understand, I hit my wife, she turns me in. You release me on $200 bail because you think I'm remorseful. Next week I hit her again. You bring me in. And you can increase the bail on me to either keep me or make it more painful for me to lose that bail. Yes? No?
You wouldn't get bail the first time because you wouldn't be a risk of flight.
If
Okay,
you,
then that's what
if
maybe
the
what I
judge,
don't understand. The
if-
risk of flight, then I guess I don't.
are you going to show up for court?
Right. Are you gonna leave? Are you gonna leave the
Are you gonna-
town? Are you gonna leave the state? Are you not gonna show up for
Okay.
your court date?
All right. But
That's
if I
risk
don't
of,
show up,
well, then
that
they'll
would-
get a warrant out
then
for
they
you.
get a warrant and I come in, that's just twice. The second time they get a warrant, they bring me in. Now what's the scenario to keep me from hitting her again?
There's conditions of release that are non-monetary that say you may not, what would most likely be a condition of release is that you are not allowed to be within 300 feet of your wife. You have to not go within 300 feet of the residence. You can't have any contact with your wife of any way, shape, or form, directly or indirectly through third parties, any type. And those types of conditions. If there was alcohol involved, there
Right.
could be a condition that you not purchase, possess, or consume any anything containing alcohol. There could be a requirement that you have an assessment and that you follow any treatment recommendations.
Right.
If you engage in that behavior again while there are pending charges,
Yes.
the second or subsequent event could theoretically be charged as a felony. If there's a felony, that could be a situation where the court finds that there's no condition or combination of conditions that are going to reasonably prevent any future violence, and the court could hold you without bail for public safety under that constitutional provision.
Okay. So what I'm hearing layman's terms, to get to a third offense, you really gotta be a pretty bad person. I mean, you can get away with it once, you can get away with it twice with conditions, but it should never happen a third time.
It does.
Sorry?
It
I
does.
think it depends on what the situation is and what the
For a
crime.
violent offender, any kind of violent offender, it shouldn't happen three times, from what I'm hearing. They should be held because because it's a third time.
If it's a domestic assault, non-felony, the individual is entitled to bail, and conditions of release. It's not one of the life imprisonment cases, and it's not a felony that would be permitted to be held without bail under 13 VSA 7553A. And so the question for the judge at that time is, what are the conditions of release that can reasonably mitigate the potential for any future violence and to protect individuals? And the court, non-monetary conditions are for public safety. If there is a risk of flight, then and only then can the judge impose bail. If there were a subsequent offense that was a felony, the state could charge that as and ask for a hold without bail at that time under 7553A, and then that statute, and then you would be entitled to have your trial within 60 days.
Thank you. You were patient with all those questions.
So as you can tell, there's a lot of frustration in the communities that there's a lot of repeat offenses by the same person. And why isn't the person being held? That's always been the issue. That's where that term catch and release has come from. Police catch them, next day they're on the street. And why is that? I mean, that's the crux of the questions here. And there's so many layers to this that one type of violation doesn't always play out the same as another type of violation. And you're dealing with misdemeanors versus felonies, which is also something we can get into. Misdemeanors are a lower level of crime than your felonies. And then there's a different set of circumstances that the court looks at. But that's this whole, issue of repeat offenders, repeat violations is what there's going to be a lot of discussion, I think, in this bill, this session.
And if I can, when you ask about the court, under 13 VSA section 7554, that's the statute that contains the factors the court needs to look at for conditions of release. When you're looking at factors, you look at on the basis of the available information, nature and circumstances of the offense, the weight of the evidence, the accused's employment, financial resources, ability to post bail, character and mental condition, length of residence in the community, record of appearance at prior court proceedings, or flight to avoid court proceedings. There's also additional factors when you're looking at the public safety that are those same factors generally. They also had whether at the time of the current offense or arrest they were on conditions of release or some type of personal recognizance, whether they were on probation, furlough, parole, or other release pending sentence appeal or a sentence, federal or state, whether in connection with any criminal sentence they've been compliant with court orders or failed to appear at hearings. And recent history of actual violence or threats of violence can be considered by the court on their mental bearing on mental condition and character. And so what the court has to do in those circumstances is look at all of that and decide, is there a risk of flight? And then if they find a risk of flight on a case that is not one that you can hold someone without bail, the court can impose bail.
Sounds reasonable. I guess I just don't understand why the perception is we're unsafe.
It's a lot of spin out there. Welcome to the world of political spin.
And if
And
that's the case,
perception.
then we need to block out the spin, but
And perception. Perception sometimes becomes reality.
Yeah, but some of it is reality of drug dealers that are being picked up, let out. And, the crimes are going up in our areas. So there's a little balance in that discussion as well.
Mhm. Oh, well,
Yep, Judge Dunning, could you restate which statute that?
13, Title 13, Vermont statutes annotated section 7554.
Okay, that's what I wrote down. And that's
Bail and it's called release prior to trial.
okay.
And there were a number of changes made to that within the past several years that tied into what the judge needs to look at and consider.
Well, and so it's a follow on, can I? Yeah. This perception that we're all talking about, I mean, is a lot of that because these aren't violent crimes, many of the nuisance crimes. So you have the same, say, 10 or 20 people in a town doing these sorts of low level activities. And because of the backlog, they're not getting a trial. They haven't yet had their chance in court. They're not proven guilty. So the same folks keep getting out, right? I mean, there's no way around that, is there?
You are correct that one of the factors is that someone who is perceived as in continuing to engage in illegal behaviors and keeps getting charged with conditions of release violations. The way we get rid of conditions of release violations is to not have conditions because we've had the trial.
Yeah.
And so what we need to do and what our goal is to shrink the time between your first appearance in court and your disposition of your case, whatever that disposition is going to be. And with respect to those types of cases, one of the things we're trying to do is to say, okay, if you have someone who has a large number of cases, we need to make sure that we get that person in soon. In other words, we have to start moving those cases. And so steps are being taken with additional jury trial days to get those cases coming in, identifying the cases where we have numerous charges and repeat charges, and to say, okay, we need to get those cases in. And so those are discussions that judges have. They are things that we talk about and are striving to move forward on.
Right.
But we have to shorten that time. You are correct.
Yeah.
Other thoughts? Question? So as a follow-up to this for testimony, as a follow-up, what I would like to do is spend some time with the courts and with DOC and with our ledge counsel to go through our pretrial supervision language that we put in place last year. Because that really starts addressing this issue of person is charged, arraigned, and they're released on conditions. And we put in place a mechanism called pretrial supervision for folks out in the community. We did this last year. It's being carried out in 2 counties at this point. Up north, it's Essex Orleans, I believe. But I would like to get Ledge Council to go through the law that we put in place last year, and DOC, because they're the ones who are going to be implementing this, and the courts to explain what pretrial supervision is. Because this conversation we just had on the catch and release, and why are people still, coming through the courts, they're charged, they get conditions, they violate, they're coming back. How come it takes 3 or 4 times before we hold them? Pretrial supervision was an attempt to start dealing with that cycle and provide more public safety out there. So I'd like to schedule some time, and maybe, before everybody leaves today, you could give some times that might be available for Phil for this.
This may be, is arraignment, the expenses associated with arraignment coordination funded by judiciary or DOC or a hybrid thereof?
Arraignments are through the.
Well, it depends. We
It's
have
not
one,
DOC.
we have regularly scheduled arraignments every week. So in our courts, when a law enforcement officer cites somebody to court, they'll cite them to come to Windsor County to court on Tuesday morning. And so Tuesday morning, there's a bunch of people that show up at the courthouse. The state's attorney has filed charges, the public defenders are there, and the process begins with the arraignments. DOC is not involved generally there. If, however, someone were arrested the night before for a charge and they were held on bail or held without bail, DOC would be involved in that arraignment. That's a lodging, and that's generally held at 1:00 in some counties, 11 in others. And DOC would be responsible for helping on their end, and then the court is responsible for what we're doing in the courtroom at that time.
Oh, I, to say the individual is held and the sheriff, deputy transports the individual to the court for the arraignment. He pays the deputy. Sorry, that's really not too far.
We're gonna get into
All
that.
right, I'll stop. No, I'll stop. I'll withdraw my questioning.
I could give you the quick answer. There are statutorily, I believe it's 24 transport deputies or 22 authorized by the state of Vermont.
State.
Are state employees that are supervised and assigned to various sheriff's departments, and they do transports across the
Comes
state.
out of our general fund. Does not come out of DOC's budget. Comes out of the general fund.
Yeah.
Budget. That's all part of our state budget. What happens in the courts, there's money from our state budget that goes to the courts to run all these trials, to run all these arraignments. We got money that goes to the state prosecution, state prosecutors. They get paid by the state. We have money that goes to the Defender General. It's all coming out of our general fund budget. So when you're talking about a general fund budget of a couple $2 billion or 1 billion, whatever it is now, this is where it goes. You want these services, got to pay for it.
No, I understand that, but I
That's
just
where it's coming.
understand how it flows.
Yeah.
Or
It's coming from.
our friend down the hallway in judiciary, Tom, he can tell you, that's what he used to do. He can tell you about it.
Tom Burdick.
No.
Oh, Tom Oliver. Yeah.
Does he remember that far back? He's retired now.
5 months, 4 months.
Kevin.
That's the funniest thing I've heard so far today.
Yeah, and he did just retire. He'd be a great resource to get
He's a
questions.
great resource to
I
you.
know Tom pretty.
Kevin?
Judge, would it be a fair assumption that we would not detain someone unless it was a felony?
No, there's oftentimes individuals who are charged with misdemeanors are detained. If you have someone who is charged with domestic assault and the court thinks that there's a risk of flight, it might be a misdemeanor first offense domestic assault. But if you mentioned about yourself, if you had said to somebody, if I get out of here and you tell the cop, if I get out of here, I'm going south, I'm going to the Keys, they're never going to see me again and I'm out of here. Well, that's going to get to the judge. The judge is going to say, this person's a risk of flight, and the judge may impose bail. So in misdemeanors, you can have bail imposed. It's just, again, that the question is of whether or not there's a risk of flight.
Not gonna show up.
The $200 limit is only there for cases that aren't a violation of probation, a violation of conditions or new charges. So if you did something there,
Sounds like solid problem. And I've probably already seen the chart, but if you were to break down the 1,482 individuals that are detained right now in terms of why they're detained, was it
1,400.
You mean the 510 that are detained? There's
Well,
14,
They're not
100.
sentenced.
no, there's 1,400 plus total in our correctional facilities, of which 500, I'll say 500 of them are detainees.
Right.
So you're talking about the 500?
Well, I'm talking about the total population,
Okay.
the offense or the alleged offense. Is that, I'm sure you've got that kind of statistic.
DOC actually has those charts.
Yes, that-
We have those.
Yes,
can go-
DOC, if you said to me, can you get that? I'd say yes. Josh, can we get that? That's where we get it from DOC.
We'll have testimony on that. That's something that we can, because you always give that out to us too.
Thank you.
So we gotta start closing this up because we've got some other folks here waiting. And I think this has been very helpful.
Thank you.
Thank you very much.
If anyone has any questions, please let me know. Do not hesitate to reach out, whether it's by email, thomas.zone@btcourts.gov, or if you see me in the hall, please don't hesitate to stop me and ask me questions that you may have. I did check, Madam Chair, to see if I had a response from Greg yet. I do not, but I will get you that information.
Okay, that sounds great.
Thank you. And Phil, want to let me know what might work for me. Just zip me an email and we'll put it together. Thank you all. Have a great day.
Want to keep going. If you need to take a personal break, take a personal break, but we're running a little late, but I wanted to spend time now that we've kind of talked at the front end in terms of what happens on the court and then folks come into an incarcerated setting. I wanted to talk about how our beds are utilized in our correctional facilities. I think this is real fundamental information that we're going to need as we move forward in discussions of how our facilities operate, particularly when we get into replacing the women's facility or any other facility. It's really important to understand how the beds are utilized, because you can hear that we have a facility with 350 beds and you think, oh my God, we got all these people we're incarcerating in these 350 beds, when in reality, out of those 350 beds, maybe 100 beds are flexible in use. So we need a real basic understanding. Josh, welcome back.
Thank you. A bunch of new faces this year.
Yeah, we
Welcome.
got 6 new members.
Joshua Rutherford, Facility Operations Manager with Department of Corrections. You've asked, I have earn time and bed utilization. I was going to start with earn time because it's easier, but we can flip that. It is. We can flip that if one is more important to
The
you.
bed first.
Okay, let's do that. The other thing I will mention, and the judge pointed out, it is a Monday after a holiday weekend. So we have 510 detainees today. On Friday, we had 473, which is still quite a bit, but there was a sizable increase just over the weekend. And that's not entirely unusual, especially over a long weekend. And as the judge said, a number of those folks may leave today. It's not uncommon for us to see that spike on a Monday or a Tuesday for a long weekend, and that starts coming down afterward.
It's a holiday weekend,
Yeah.
so a lot of activity in different ways. Sean,
Just quick, so the 464 on Friday,
473, yep.
473, is it the same people still there? Or is this a new group of?
It should be, very few of those people would have gone anywhere between Friday and today.
Okay, so that's
Maybe,
people.
right, maybe somebody posted bail, 1 or 2, but by and large, that group that was there Friday would still be there.
Okay, thank you.
Plus anybody who got held over the weekend.
Yeah, gotcha.
it's pretty consistent, high 400s.
And has been for a while.
Pretty consistent. We've tried to get that down.
And one more on that. What percentage of those that are weekend visitors show up the next weekend or the following weekend? Is there any idea how that works?
It would have been a better question for His Honor before he left. I don't think a ton, because as you know, as the judge mentioned, if folks are showing up, especially for violent crimes, they get more likely to get held. But conceivably, there could be some folks who make repeat appearances, especially on those lower level offenses. A lot of those folks are cited and never come to us. So like a misdemeanor property offense, which certainly has disrupted the community, no doubt. But that person might never actually come to us and be lodged. They might be cited for a court date on Tuesday, and they show up on Tuesday and never would have come to corrections.
Yeah, no, I'm just talking about the ones that.
Those violent offenses, yeah, those. I don't think that we would see those for folks on sort of a repetitive basis. before they ended up hanging out with us for a longer period of time.
Do you have something?
Yeah, sorry, Josh, for jumping on.
That's okay, that's okay. I'm here.
So, I'm just trying to get my, I don't want to be irresponsible throwing around the cost per bed number, which I just did in the previous one.
Yes.
So it's that would be indistinguishable between the sentenced and the detained population because they're intermixed anyways, right?
Yeah, we don't break those out separately. We
Okay.
provide the same services.
But it's also got to be economy to scale. So if I'm telling the judge, if we get so many people out of there, going to reduce 80,000 per bed. That's not right, is it? Because a lot of these costs are the workforce. And
Right.
what does that include, the cost per bed?
Well, I mean, a lot of that is our staffing. We have to maintain these facilities 24 hours a day. We have to maintain medical coverage in these facilities 24 hours a day. Certainly there's sort of individual medications and medical care for Bob. There's food for Bob. But the building itself, we have to maintain whether or not Bob's there. We still have to have officers there. If you get rid of 50 people or 100 people, now we look at a point where maybe we can reduce something, close a unit, one less unit, absolutely. But if you're talking this 1 to 10 people are out, we don't see a difference in our budget there until it really gets to a point where, you can close down a unit or something like that. And I'm still going to need, say a nurse there. So to say, reduce a nurse, I'm going to have to reduce population of facility by 150 or 200 before it makes sense to do that. So there's certain fixed costs that are baked in. And those move only a little bit based on individual numbers until we start getting to the points of 50s and 100s. And then it can start making more of a difference.
Great, that's helpful. Thanks.
And the flip side of that is because we have our facilities are fairly small, it's going to cost you more than if you had one large facility because you're going to have less staff, the larger your scale, the less just like our schools, same thing. And
we have that, but we also have a number of our facilities are fairly outdated. And part of that, and Chittenden Regional is perhaps the worst of that lot, but you'll see the same thing in Marble Valley, Northwest, and Rutland. The units are smaller. So you have one officer watching 20 people or 30 people. Well-designed unit, an officer can easily manage 50 people. And that's what Southern State has. A couple of the units in Northern are even larger than that. So those lines of sight aren't great in Chittenden. Maybe one officer could watch 40 people, but they're in 2.5 units. I can't really do that. If I had one unit that was well-designed, that had great lines of sight, and that's when we've been talking about the women's facility. That's one of the things we've been talking about is, can we set it up so that, maybe the units aren't big, but I have 2 of them next to each other so that at night I can have one officer watch both of them. That's a way that if it's set up right, you can do that. But our older buildings just aren't set up that way. And they're not flexible enough to make that work in a way that's safe for our staff or for the incarcerated population.
I think this might be a good opportunity to invite folks. We do an annual trip to Maine. I know some folks have been there to see the women's facility, the Grand Tree facility. And just to illustrate Josh's point, I think we'll show slides of it at some point in this session. But there's an officer's podium in the reentry setting, and they actually can look at basically 4 units at once with one officer. And it just has a very different feel, both kind of the physical layout, the materials they use, but I think that will help illustrate a little bit. Or, we can visit facilities in Vermont as well, kind of get a sense of some of that aged, inflexible infrastructure that we've been talking about and to see.
So do you have photos of that?
Oh, yeah.
Yeah, I can.
Yeah, so that would just send out. I'd love to see the pictures. I don't know if I'm gonna get to Maine anytime soon. We'll go, but
A 5-hour drive.
but if you have pictures, that'd be
That's
great.
fine.
I'd love to see that.
Yes,
And even like you have a floor plan. Anyway.
here.
Let's go into how our beds are used. And I hope you have a breakdown, some of it from facilities.
I do indeed. So a bed is not a bed, is not a bed, is not a bed. Quite seriously. So we have in each facility, we have what's called general population beds, which means really anybody can go into one of those beds.
Remember that term, general population.
And those are more flexible beds. We can put a wide variety of folks into those beds. We do generally mix sentenced and detained. Just because of the way those numbers are, there's no great way to split those populations and provide all the same services to everybody. You don't have to duplicate services. And it's just not practical to do on the numbers that we have. But we also have a number of populations that require different beds. Now, huge percentage of folks in our system have medical or mental health needs. Basically the baseline. That being said, some folks have advanced medical needs. We have folks who have serious injuries or serious chronic diseases. We have folks who are approaching end of life care. And so, or have had an acute injury. So we have specialty medical beds, for those individuals.
Are they all in the infirmaries?
Not necessarily. We have, and I'll get into the breakdown by facility when we get there. We have infirmaries, but we also have a unit in Southern State that primarily holds kind of a geriatric population. They might need a little additional support with activities of daily living. The cells are single celled and usually a little bit bigger because folks have more mobility needs. You can fit a wheelchair or a walker in, so easier. An LNA goes over and helps folks out with a little thing. They don't need an infirmary level of care, but they need a little more than somewhere else. And then we have actual infirmary beds. Mental health, we have 2 units in Southern specifically. One is for folks who have serious mental health issues, are kind of stable, but need some additional supports. Really wouldn't do well if they were in a general population setting. Sometimes that's temporary. You really get somebody stabilized and then they can go on. And for some folks, that's more permanent. They're not going to hit a level of stability where they can manage in general population. And then we have a much smaller unit that really is an acute setting for folks who are having a serious mental health issue and are in some sort of active crisis. And they need a high level of support, a high level of observation. That and the infirmary are our smallest units, smallest officer to incarcerated individual ratio, because those folks really need a high level of support. Risk intervention services, most of our folks who are engaged in services do reside in general population units, but in Northwest State, we have a unit that is dedicated just for folks who are engaged in our sex offender programming. Vermont does not house all sex offenders in their own individual units. We run probably the safest system in the country, and that does work with some care and attention, but that does work. But especially when those folks are in programming, we found it works better for them to be in a distinct group. They may have programming materials that other folks don't necessarily want to be exposed to. They may be dealing with either their own trauma or, say, writing assignments about their risky thoughts and things like that. And that's just something that's not going to go as well if they're mixed in with population. We do have 2 honor dorms, one in Southern and one in Chittenden. Those are units that actually don't have a living officer assigned to the unit. There's behavioral contracts the individual is engaged in. That's something newer that we started doing in the last couple of years. It's actually worked really well. There was some skepticism initially how well that would work. It's worked well. But again, that's not a bed I can just randomly select somebody and say, oh, here you go. We've really got to make sure that that's folks who are willing to engage with that kind of program and meet the behavioral expectations and agree to them. Restrictive housing and close custody. We have folks who behave poorly sometimes, even after you send them to corrections, they still continue to behave poorly. And so restrictive housing and close custody provides housing for folks who behave in a manner that's violent or disruptive while they're incarcerated. The department's done a lot of work on restrictive housing in the last, well, it's been longer than I thought, 8 years or so. It is also a critical feature of making sure that we have a safe system is when somebody is going to act in a violent way or has demonstrated over time that they act violently, separating them from other folks so that they don't continue to harm people is critical to making sure that we have a safe facility.
So Josh, I want to interrupt you.
Absolutely.
Bring something up that's a little different, but it's sort of connected. Minimum security.
Yep.
Medium security, maximum security. Okay. Come in here and you have the concept of more heinous the crime, the higher the security level that a person needs while they're incarcerated.
Yep.
They all come in with that. They murdered somebody. It was a violent offense, sexual assault of a child, sexual assault of a person. Those are violent crimes. They need higher security. I think it's important to share with the committee what we have for security. We don't have a maximum per se. Our facilities are medium. We had one facility, Windsor, that was minimum security. Basically, that is determined how many walls of separation from the inside where the offender is to the outside determines if it's minimum, medium, or maximum. The more walls in between determines maximum or medium. But how does correction determine what the security level is of a resident in a facility?
Absolutely. So there is an important distinction between community risk and security classification. Community risk is if I let you go, how likely are you to do something again in the community? Institutional risk or security classification is how are you going to behave while you're inside? And that includes things like, are you going to attempt to escape? When somebody first comes in, we have very little information about them other than that initial charge. So we sort of start with that and what else we know. There's some other factors that correlate with folks' risk. But we have an assessment tool that assesses where folks are. Over time, the longer they're in our system, the more data we have. And we have folks who have committed very heinous crimes who do very well while incarcerated. That does not necessarily mean I believe they would do well if they were released. Some of them perhaps, some of them not. But they do very well while they're incarcerated. And you may have someone who's done something fairly egregious, who has a fairly low security level in a facility. So we have 3 security levels in the facility. We have minimum, medium, and close. Some systems also have max, which is on top of close. We only have 3. We don't have any maximum security in the state. Close is our highest level. Below minimum, we also have folks who we will approve to go out and participate in work programs in the community. It's a very small number because we really don't incarcerate many of those folks in below, but it's actually sort of below minimum. They have to be minimum custody plus meet these other criteria. So those are our 3 levels. Minimum and medium doesn't see a dramatic difference while they're incarcerated. But close custody, and again, some of that comes down to numbers. In a system where you have 30,000 incarcerated folks, you can set up whole facilities for it. These are my minimums, these are my mediums. With our numbers, it doesn't make a lot of sense to do that. But close custody really is held separately. They're housed together and away from other folks that they might harm. And usually not usually, always with a lower staff to incarcerated individual ratio. It's a small number of our population, but it's those who have really demonstrated, usually over time, that they're going to cause chaos, violence, disruption in the system. It is impossible to walk in the door as close custody. No matter what crime you come in, it's impossible to walk in the door as close custody. We would have to see some level of disruptive behavior inside to reach that level.
So it's a person's behavior inside the facility that determines what their level of security
That is security classification is all about your behavior in the facility.
Not the crime you committed.
The best predictor of how you're going to behave in a facility is how you behaved in a facility. So yeah, and crime is one of the things. Certainly folks that engage in violence are more likely to engage in future violence. But the longer somebody's been incarcerated and not engaged in that behavior, the more confident I am feeling that they're going to continue to not engage in that behavior.
I think this is really important for the committee to understand this, because we all come in thinking, oh my God, an egregious crime, they're in the highest security in a facility, and that's not connected.
For some folks, and you think of folks who have offended against a child, their victim type simply is not present in the facility. Those folks may behave very well in a facility. A lot of folks who have committed murder after a certain period of time really sort of settle down. They know they're going to be there for a while. This is their home. This is their home and community. It's going to be for a decade, 2 decades. And folks sort of get accustomed to that. There's a real benefit to them for facility being quiet and safe. And so folks do settle out. But it really is about facility behavior more than anything else.
And that determines really in some ways which beds you go in, because
it certainly influences.
If you're playing by the rules while you're incarcerated, chances are you're going to be in general population.
Well, rules, or you have one of these other special needs. So keeping going with that, protective custody is for somebody who's not safe in population or doesn't feel they're safe in population. Like I said, we do run what is one of the safest systems in the country, and our protective custody rate is very low. And for most of those folks, it's a very short period of time. And then we, make arrangement. Maybe they need to be in a different unit. Maybe they need to be in a different building. Small communities. Sometimes you have folks who have, very, very public crimes, where there's some outrage. But it's not uncommon to have somebody where, they've offended against a family member of someone else who's incarcerated. Or these two gentlemen were involved in a crime together and one is upset, the other might be working with prosecution or they think they are. Those sorts of things. That doesn't necessarily mean I need to keep that person in protective custody, but I might have to keep them there for a couple of days until Mr. Pasha can find another facility to put them into. And that is, we're able to do that a lot. A lot of folks who in other systems might require protective custody, folks who are vulnerable because of their sexual orientation or what folks perceive that to be, folks who are younger or older, who have some level of developmental disability, sex offenders, folks who are informants. In some systems, those folks sort of all end up in protective custody units. And in Vermont, most of those folks, most of the time, can be housed in general population with some careful attention to where I put them and who they live with. Doesn't mean you can take this 20-year-old kid for his first time in jail and put him with anybody. But there's a place almost always in general population where that person can be placed with a little bit of attention to, no, this is the right unit. Yeah, this is a cellmate that, we're not concerned is going to victimize them. And we'll talk a little more in intake about how we get to there. Work camp. Now, the state we used to incarcerate about 2,400 people in the state, and Chair would remember that. And at that time, we had over 200 people in work camp, 100 plus in Windsor and another 100 in St. Johnsbury. We're down 900 from that. What a lot of what's no longer incarcerated, a lot of folks who are no longer incarcerated, those who are on those lower level, low risk offenses. So we've had a dramatic reduction in the number of folks that really are appropriate for a program like that. And so Windsor closed down. We really didn't need that space anymore. We really didn't have the folks who were appropriate for a minimum custody setting. Windsor for years didn't even have a fence. Then we did put a fence around it, but it was a single fence. And we just don't have a lot of folks incarcerated where that's appropriate anymore. We do still have one building at Northeast in St. Johnsbury that is a work camp. Folks there do still go out into the community and do some projects. It's a fairly small number now. We have a lot of trouble keeping that building full. Usually that building's, about half full, Jordan? And I think that is a sign in some respects that the folks in this building and the Judiciary and Corrections did a good job in looking at who is decarcerated, because what you would like to see if you're reducing incarceration is you're reducing low risk nonviolent people. And those are certainly a class of folks that we had incarcerated that we don't very much have incarcerated anymore. And then admissions. And when folks come in, and I think I have a slide coming up on admissions, but when folks come in, they're initially held in admissions until they're assigned to a unit. So if you want to jump, Isaac. So this is our honor dorm in Chittenden. These are lower. There's not a unit officer assigned there. There's not an officer in that unit. The incarcerated individuals sign themselves in and sign themselves out. They have a way to access emergency help if they need it. We do go in and tour it on a regular basis. And what I like about these photos is they show two things. First of all, staff in the incarcerated population have done a lot to try and make these look less like a traditional prison. I worked this unit in 2002. It did not look like that. The other thing is it shows where our facility doesn't necessarily do what we want it to do. So you've still got bars in the window. If I stand and look out that window, there's still razor wire. These bunks, they have nice crocheted blankets on them. They're still metal bunks set up in bunk bed format. The building, that's not how I would design a dorm for low risk folks who are going to behave. Staff have done a great job, and the incarcerated population has put a lot into making that as great as they can for that environment. The environment also places some limits on us and how well we can do that. And when I'm sure we'll be back to talk about proposals for the women's facility, But that's one of the things that we're looking at is if we're going to have an honors dorm for folks who are going to be well-behaved and nonviolent, does it have to be all concrete and steel and designed for men who break things? Because that's what that unit was designed for, is detained males in the 1970s. That's all concrete and steel because they break things. The population that's in there now is not going to break things or is highly unlikely to break things. You could have a different environment. Again, the staff really have done a great job. Superintendent Messier and her team have done a lot, and down in Southern State as well, Superintendent Merrill and her team, to make those units as non-institutional as possible within the confines of what they've got.
What's the square foot? I'm sorry.
No, go ahead, Kevin.
What's the square footage of this roughly?
I don't know off the top of my
It's
head.
big as this.
Got them, but yeah, I'm sure we
It's not
can.
critical, it's just.
Yeah,
The cell would be about half of the size of this room, wouldn't it?
probably smaller than that.
Yeah.
By 20, 12 by 10?
Yeah, something like that, I think.
Looks bigger than, that's why.
So, these are some other factors that don't necessarily usually, well, to some extent require special beds, but have to take into account, and, it's Mr. Posher's job. But figuring out where these folks go. So I'm gonna start with CPAPs. Sounds like a simple thing. We've got 2 facilities that don't have electricity in the cells. If somebody comes in with a CPAP, they can't stay there because their CPAP doesn't work at night. Keep aparts, I already talked about. You've got incarcerated individuals with conflict. We're a small state. We have staff who might have a relative who's incarcerated or might have been a victim of a crime, or their family's been a victim of a crime. That's an awful situation for the staff member and the incarcerated folks. It's not really fair to anybody. So those folks, if somebody comes in and their brother works in the facility, or the person they offended against works in the facility, then we should put them somewhere else. Just in fairness to everybody. Crowding is one of the biggest risk factors in corrections for bad outcomes. I've spent close to a quarter century than I'd like to admit studying major incidents in facilities, and overcrowding is almost always one of those warning signs that precedes it. It either made it worse, it made it possible, or it made it harder to contain when it happened. So they're constantly moving folks so that we make sure that no facility is overcrowded. Our population centers in the state are largely along the western corridor, and our largest facilities are largely along the eastern corridor. So we get a lot of intakes in Rutland, Chittenden, Franklin County, Northwest, and then our largest facilities are on the other side of the state. So we have to move folks back and forth to make sure that nobody's overcrowded. One of the things that we do in intake, everybody who comes in is assessed for potential risk of being a victim of some sort of sexual abuse while incarcerated, or committing some sort of sexual abuse while incarcerated. And so that's something that we assess for every person who comes in. And then that is looked at in people's housing situations. Heightened security needs. We talked a little bit about close custody, but sometimes people make lousy decisions or have a history of making lousy decisions. I mentioned vulnerable populations. We also have transgender, intersection, gender diverse population. And that's a very different conversation in 2025 than it was in 2015 or 2005. And looking at how to house those folks in a manner that's appropriate, that's safe for them, and that's safe for everybody around them. And then individuals who are under 19. So if they're under 18, let me back up. If an individual is under 19, there's limitations in Vermont law on what they can be charged with. You can start in criminal court for the big 11 charges, plus 3 new ones that are added that are limited. There you have to be 16 plus on those. So 11 plus 3. It used to be the big 12. You'll hear that a lot. There's no longer a big 12. There's 11 plus 3. Other felony charges, any other charge for that age group has to start in family court. Felonies can be moved up to criminal. Realistically, that doesn't happen very much, but a younger person charged with a felony in family court can be moved up to criminal, but it can't start there. Misdemeanors can't come to criminal court at all. So when we get these individuals, if they're under 19, as the judge mentioned, they have to be sight and sound separate until there's an interest of justice hearing. And at that, the court looks and determines, is it appropriate for this youth to have sight and sound contact with adults? Probably in an ideal world, you wouldn't do that at all. The problem in Vermont is we've been so effective at steering youth out of our facilities that we might have, what do we have this one, 3 18-year-olds? Plus or minus? Okay, and nobody under 18. So if I were to hold all of my youth together and not with anybody else, there's 3 of them. Sometimes there's 1 of them. If I'm talking about folks who are under 18, very often it's 1 or none. So you start talking about holding folks. If I'm going to maintain sight and sound, I'm really going to have to isolate them and keep them away from everybody. And that comes with its own risk and its own damaging thing. So there's a balance the court has to make. For individuals who are under 18, irrespective of that, they have to live in a unit without adults, but they can participate in services outside that unit under direct supervision. And again, a lot of that comes back to, we don't want to take a 16-year-old and hold them in a unit all by themselves and not have contact with anybody while they're incarcerated. That's really unhealthy. So those are all special populations. Aside from the youth, none of them necessarily need their own unit or their own specialty beds, but those are all things we have to take into account when we're figuring out where to house people.
So the ones who are under 19 that you do periodically, normally they would have gone to what used to be Woodside. We'll get involved in this committee one way or another with the replacement of Woodside, which right now is being discussed in Virgins with the state entering a design build for a facility to house our justice-involved juveniles. But we're going to get involved in this one way or another. What facility, if it's a male, what facility do you use? Is it Marble Valley and Rutland?
Marble Valley is our primary. We have a small unit there. Because we have a small number, you have to take a whole unit offline. So it makes sense to use one of our smallest units for that purpose. Northeast, which uses the same blueprint, in St. Johnsbury is sort of our backup if for whatever reason we need to. For most folks who are 18, I think all but one 18-year-old, after that court hearing, interest of justice hearing, they've been able to be housed in general population, but with some real attention to where we're housing them, with a special plan for them. But for folks who are under 18, they usually continue to be housed in Marble Valley or Northeast as it's appropriate, because that's where we can maintain the sight and sound.
Brian?
Backing up one group to the transgender, gender diverse, I assume this means there's some non-zero number of folks who fit that category.
Absolutely.
And so I guess I'm wondering, how they're housed, if this is a person with an XY chromosome identifying as women, are they in the women's prison? And can anything, and this is sort of the drive of it ultimately, whatever happens at the national level in the next few years, does it change whatever you are all doing?
Okay, so that's
I know.
a big question. That's great. So
Spending time on, right?
well, so there's last I counted, there's about 16 folks in our system who identify as transgender or non-binary. That fluctuates a little bit, but 16, 18. Those housing for those folks is made on an individual basis. We look at each individual case. We start by asking them what's their opinion? Where do they want to live? That is not the only deciding factor, but that is the first question, is what's appropriate for your safety? For transgender men, they usually prefer to live in Chittenden. Even though they're male, they're often smaller, and they feel they may be at more risk in a men's facility. Usually they've asked to live in Chittenden. For transgender females, those requests, some prefer Chittenden, some prefer a male facility. Once we have their opinion, then we have to look at the person. What has their behavior been during incarceration? What are they in jail for? We've had folks come in who are in jail for violently sexually assaulting women. And they're a transgender female and they want to be housed in Chittenden. And we have to look really carefully. Is that going to be appropriate? Is that going to be safe? Nationally, this is a challenging conversation. And there's actually 2 of us in our department, myself and Ms. Sprafke, Director Sprafke, who sit on a national network that's trying to talk through these issues and what our best practices. And really, the gold standard on practice really is that at this point is that individualized review. Nobody's been able to come up with sort of a gross assessment tool or some sort of line cut off to say what's appropriate. But it is looking at somebody and making a decision about what's going to be safe and appropriate for that person and for everybody around them. At this point, about half of the transgender females in our facility are housed in Chittenden, and about half are housed in male facilities. If that answers, the second part of your question, what's going to happen in the next couple of years?
It's already happening.
Yeah.
Yesterday, the president of the United States did issue an executive order relating to gender identity, saying the US government will only recognize male, female. There was a component of that did extend to the Department of Justice, saying that biological men will be not housed in female facilities in the Federal Bureau of Prisons. That was issued yesterday.
Right, thanks.
One of the things we know is that population can be at increased risk of being a victim of sexual violence while incarcerated. And we have placed, I was involved in one of the first placements of a transgender female from a male facility to a female facility when I was superintendent of Marble Valley in like 2017. And this is someone who had really struggled in our male facilities for many, many years. They were known to us before I knew the word transgender or knew what that meant. I knew this person. And it was interesting because that was novel for the system at the time. And it worked really well. All the historic problems they'd had in male facilities largely didn't exist in when they moved to gender. That worked for that person. That worked. That's not going to work for everybody. We do have to make that individual look, but that was an eye opener for some of us, that this really was functional for some folks and reduced their risk and didn't increase the risk to the population that's housed in Chittenden.
So if it impacts the federal systems, the state systems are still autonomous from that?
Without stepping too far outside of my bounds, I'm not aware of any intent on our part to move away from where we're at. The state's worked really hard to stay ahead on this issue, to learn and to be open to change. And we issued a policy on it in 2015, which was one of the first kind of comprehensive policies in the nation. That's when we introduced pronouns. Folks, whatever your pronouns are, whether you're housed in a male facility or not, whatever your pronouns are, we'll use them. And some other protections for that population. And then we've been working in the last couple of years really on redefining that policy to meet where we are in 2025, because there's been a lot of social movement in that area in the last 10 years. And it really is about better recognizing a population that was there, but we didn't treat any differently, didn't really recognize those differences or make accommodation for them when I started in the department in 2001. And we're a better department for it, and it's better for those individuals and safer.
Or security in the building? Right.
So I just want to make sure I have this right. So policy that is applied to Vermont inmates has to also apply to Vermont inmates who are in Mississippi. Is that accurate?
Our contract with Mississippi is, we have a contract with Mississippi and we impose certain things that, they have to do in order to meet our contract.
And that doesn't necessarily extend to Vermonters who are housed in federal facilities?
No, because they're not under the jurisdiction of the Vermont Department of Corrections. They're under the jurisdiction of the Bureau of Justice.
Excuse me.
So intake, we are, as you've heard, a mixed system. Folks very often come in directly off the street. They've been arrested. I was a third shift supervisor for like 5 years. And nobody comes to jail because they're having a great day. I mean, it seems like an overstatement, but seriously, folks show up, they're having an awful day. Very, very, very often they've been using drugs or using alcohol or are detoxing from one of those things. You may have medical needs that folks weren't taking care of. You may have medical and mental health needs that folks weren't taking care of in part because they were using drugs. Someone who's actively using fentanyl may not be taking great care of their other health conditions. Folks come in the door and frankly, folks are often a mess. You know, and it's difficult to sort that picture out too. Is this an underlying medical issue or is this the fact that the person was using fentanyl yesterday? And so those first couple of days really involve a lot of close observation to figure out what's going on with somebody. So when folks come in the door, we do a medical screening, we do a suicide risk screening, we do that PREA screening I mentioned in terms of sexual victimization, sexual predatory risk. For folks who are pretrial, they'll then go to arraignment on the next business day. There's a mental health assessment that would be usually after arraignment because those folks are in sort of on a Monday through Friday schedule. Arraignment's usually going to be the next business day. And then after that, you have the caseworker meets with them. They do their orientation, their initial classification. They go over sort of the rules. How do you get your needs met while you're incarcerated? And then they pick a living unit and assign that person to a living unit with the living unit supervisor. That's also our first screen where we start to figure out whether or not somebody might need one of the specialty beds. Sometimes that's really obvious. Somebody comes in and like, nope, they definitely have this need. They're going to need this. Other times it's not. And like I said, it can be really difficult when folks first come in and they've been using and folks are a little unsteady and like, no, I think they'll be okay. I think they'll be fine in general population. We're going to ask the unit officer to keep an eye on them for a couple of days though and reassess, you know, see what they look like next week, whether or not that's still appropriate. And, you know, 3-4 days later, the drugs are out of their system. They feel better, folks, they're settled. Or, ooh, nope, there's something else going on here beyond just that. And let's pull them back in. Let's look at a mental health unit. Let's have mental health meetings, those sorts of things. So really there's that initial intake where you try and screen and you catch those things, but those will also show up when folks are living in a unit. And the unit officer will catch some of those things and say, oh no, this person seems to be really struggling. And can we do some follow-up about whether or not this is appropriate housing for them?
Did you say how long intake is? Sorry if you did.
How
many days?
It depends. It depends on the person, their situation, and whether or not you come in on a weekend.
Okay.
So you're not going to go out to population until you've been arraigned. I'm not going to send somebody out to general population until they've at least seen a judge. But if you come in on a Thursday night, and you're sober, and this is your third time in being incarcerated, and we know you, yeah, I'm back. You see a judge Friday morning, well, okay, yeah, you can go back down to this unit, you'll be fine. For somebody else, you come in on a Friday night, you're intoxicated, it's your first incarceration. Monday comes around, you see the judge, maybe we're ready to put you down back, maybe we keep you for another day or two up front, so that we can just keep an eye and make sure that you're appropriate placement. So it does vary. It does vary. But people do have to hit that initial arraignment. I really don't want anybody down back before they've seen a judge who said it's appropriate to hold them in incarceration. A judge makes that decision in the middle of the night when somebody's arrested, but they haven't yet had that first hearing. And so that arraignment's really an important point. So we have 6 facilities in state. Chittenden Regional houses our females. They have to meet all the needs for the females. So restricted housing, medical, mental health, they have to do all of it. So about 59% of the beds in Chittenden are general population. So a bit over half.
We have, that's out of the 170.
170 or so, yep.
So I think it would be really good. I know you've had this at one point, a breakdown of our total number of beds system-wide, also facility-wide, and then how many of those are special beds, whatever.
We've done that. The problem is I can never get the same number twice. No, but I mean, we make adjustments to that. You know, we add beds, we create an honors dorm, we change your population. So I went with percentages on purpose because there's some adjustment in that. And most especially in Chittenden, where they kind of have to adjust to meet what the population is.
I know what you're saying, but I think for us.
I can do that. We can do that.
As legislators, I think it's important we have the actual number.
Yeah.
Because that's what people in this building and outside will focus, is that number, not the percentage of a certain shoe zone.
I know.
Well, So I don't want to do a lot of work for you, but even if it's a ballpark,
We can do that.
this is our overall number of beds. This is how many booking beds we have. This is how many infirmary beds we have or medical, just so people understand that a facility may have 170 beds, but half of that facility is tied up with booking, with infirmaries, with geriatric. So they can.
And you don't want to put folks in the wrong bed. I don't want somebody in restrictive housing who doesn't need to be in restrictive housing. If I have an infirmary, you need that level of care or you don't. And I don't want you there because I don't have a bed in general population. And I don't want you in general population when you need infirmary level care. So those beds are fixed and they have pretty limited flexibility. Yeah, I mean, that's just a challenge. Whenever you create specialty beds, it helps us serve a population better, but you take some sort of percentage off the top of what we can use because we have to use those beds for their appropriate purpose, or they really don't fit that need.
And one thing, way back, we talked about consolidating some of our facilities into one facility. And the number that was out there was 800 beds, and people flipped out. They absolutely flipped out in the building as well as outside. Oh, you're building 800 new beds to house people, which it wasn't. It was closing some current facilities and bringing our out-of-state folks back. But of those 800 beds, it was carved out for different uses. That's the information this committee needs when we start talking about replacing our facilities.
And some of that is overbuilding in areas like mental health or medical so that we can handle spikes in need and growth in need over time. When I first transferred to Springfield in 2004, we had the infirmary down there and you might have 1 or 2 patients in there. That infirmary is full. And that was supposed to fill our need for years. That infirmary is full. It stays full. The need has increased. Those sort of things matter. Marble Valley is our smallest facility. It's down in Rutland. It holds primarily detainees for Bennington, Rutland, and Addison. It's also our primary facility for individuals who are under 18. 85% of Rutland is general population. So they have a small restrictive housing unit, they have admissions, and then they have that space that we use for folks who are young. The rest of that is general population. Rutland cannot hold all of the detainees for Bennington, Rutland, and Addison counties. That building holds at most 140 and comfortably more like 130. So some detainees for those counties are housed in other facilities and come back to those counties when they have pending court dates. Northeast Correctional Complex, the facility in St. Johnsbury, that houses detainees for Caledonia, Orange, Washington, and Lamoille. It is two separate buildings. So neat piece of trivia for anyone who's interested. Rutland and St. Johnsbury were built 1 year apart and they use the same floor plan. So the same blueprint.
And they were built in the 70s?
79 and 80, I think. St. Johnsbury also has next to it the work camp, which is a separate building. It's run part of the same administration. It's the same facility, but it's a standalone building. And that is a true minimum custody building. It has a single fence around it. It has 2 open dorms and it's designed for folks who are a low risk of flight and a low risk of violence while incarcerated. And it is not appropriate to put other folks in there. The folks who are there do fine. But there's a whole bunch of folks in the system that it wouldn't be appropriate to place in those beds. So those 2 facilities combine in St. Johnsbury. So you have that work camp program. And then the other side of that facility is primarily those detainees. And that's about 47% general population. Again, you have a small restrictive housing unit, you have admissions, but then you have that bulk of beds that's reserved for the work camp. Those minimum capacity beds.
What, can you explain really quickly what work camp is?
So, yep.
Keep it simple.
Just like, yeah, it's like simple. It doesn't under.
For every day you serve, you get a day off your sentence.
Oh.
But it's for folks who have 2 years or less, or is it a year?
There's not a limit on sentence, but it has to be non-listed, non-violent, and they have to be minimum custody. Are you familiar with listed offenses?
No.
Okay, in Title 13, there's a bunch of offenses where there's identified victims, and where there's special rights for victims. Nobody who is convicted of one of those offenses can be in the work camp program. Has to be non-listed, and non-violent. And then those folks who know they can go out into the community under supervision and perform some work. That used to be really robust. We only had 200 people doing that. That was a really robust program. Far less so now, by and large, because most of those folks are no longer incarcerated or no longer have sentences of any length. So we have a much smaller number of folks involved in that program now.
So we built the work camp at St. Jay. That got built in the early 90s, about 93, 94, at the same time we built the Newport facility. And that was the first work camp. And back then, we housed a lot of low risk, low severity in crime offenders. And the thinking within corrections at that point, with Commissioner Gorchak, was why we spending, at that time, it was 30, 40,000 a year. Why are we spending all this money incarcerating folks in a hard bed when they have a low level, a low severity in terms of the crime they committed and a low risk to reoffend? Why are we spending state dollars and putting them in a hard bed? So part of the thinking was we could move them into a least restrictive bed in a work camp. They will go out in a crew every day to do work for a municipality or a nonprofit. It could be painting, it could be
We
groundskeeping.
used to have about 9 crews a day going out.
And then we expanded that because we kept incarcerating more and more people. And then we expanded that for another 100 beds down in Windsor. And then there was a plan for another 100 beds somewhere in the state, and that was in the mid-2000s, like 2005, 2006, to build another work camp. And that's when we started saying, wait a minute, our incarcerated numbers just keep going up and up and up. We can't afford this. Just can't afford this. And we've started really looking at who we incarcerate, the severity of crime, and their risk to reoffend.
And that's when you started seeing the numbers go down. But those folks are, as Chair mentioned, eligible for an extra day off their sentence for every day they serve.
One's in the work camp.
One's in the work camp. Thank you.
But we
You're
don't
welcome.
have enough people who qualify for it.
Yeah. Which is a good thing. Northwest up in St. Albans, detainees for Franklin, Grand Island, Chittenden, definitely does not have enough space for all those detainees. Chittenden County is a huge contributor. We also hold our federal detainees. We do hold some folks for the federal government. They might be in another facility, but the majority of them are in Northwest. So they're accessible to the federal court in Burlington. A small number of detainees for ICE. And as I mentioned, risk intervention services for sex offenders. About 54% of that building is general population.
Mention ICE.
I was afraid you were going to notice that.
But we're gonna look into this at some point. We'll look into this, but I just want to put this on people's radar. If there is deportation and rounding up of folks, one thing that may be impacted is correctional facilities, because they will be looking, the federal government will be looking at housing of those deported migrants to be housed in correctional facilities while the paperwork is being processed. Yeah, we're gonna have to deal with this one way or the other. And that will put pressure on our beds. That will put pressure, where do we house our folks who are incarcerated, detainees or sentenced? It may also impact our contract with Core Civic in Mississippi, because a lot of the private companies have agreed to house migrants who are being rounded up. Which then means if that happens with our 120, 25 folks who are down in Mississippi, will then be shipped somewhere. So we've got some implications here if this does come to fruition in terms of how it impacts corrections.
And I'll defer most of that to the commissioner. The one thing I'll say is for the folks that we have currently, it's a fairly small number, and they're usually only with us for a couple of days, usually under 72 hours. But there's a lot of conversation about what could change. And I think there'll be conversations that are well above my head in terms of how the best way to respond to that is.
When you say a small number, do you have an idea?
14 today.
14, and that's after the weekend. Yeah, it fluctuates. I mean, you might have, Jordan does the numbers every morning, but you might have one or two. You might have, I think the highest I saw was 18 in the last couple of months.
And how long did they stay?
16.
8 hours?
Usually no more than 72 hours. And some outliers might go a couple days longer, but it's usually no more than 72 hours. Northern State is our largest facility. It's up in Newport, built in, I believe, opened in 1994. It houses detainees for Orleans and Essex, but it's also overflow for detainees from other areas who don't, there's not enough room. And especially Chittenden County because it's reasonably close, so we can get folks back over to St. Albans when they have court coming up. So you go to Chittenden County detainee, they don't have any court scheduled. Might be happening more than, and then we get notice from the court that, you know, February 5th, they're gonna have a court date. And somebody will send Jordan an email, and he'll arrange for them to move back to St. Albans, so they're available for their court date. We also they have a small infirmary, and we do, our largest risk intervention services up there for violent offenders. But those folks do live in general population. Those are general population beds. We don't usually find it, we don't find it necessary to separate them out from population, while they're doing that program. So 93% of Northern is, general population. Small infirmary admissions, and then small restricted housing and close custody area. But really, that's where a bulk of folks are, general population. Southern is our newest facility that opened in 2003. It houses detainees for Wyndham and Windsor. It also has those two advanced medical units. So you have our largest infirmary. You have that unit that is largely geriatric in nature. And then you have the two mental health units, the one that's acute and then the non-acute one. And you have our largest restrictive housing population, the largest restrictive housing units. So if you have someone who's really dedicated to engaging in poor behavior, they may end up in Southern. It's also the only facility that's flat, which makes a difference. If you've been to Newport, if you've been to Northern, they built it on a hill. And if you use a wheelchair, that is a really unfriendly facility to be in. And we got a couple of guys who will tough it out and are good with it in July when the weather's nice, but nobody wants to roll a wheelchair up and down that hill 3 times a day for chow in February. So Southern is really where most of our folks with mobility issues end up. Most of our other facilities, there's steps to cells. So you're up steps or down steps or whatever. So Southern has, even for folks who are not in that geriatric unit or in the infirmary, that's our flat facility. It's built on a hill as well, but we built it on the very top.
So that was our party area. Joe's Pits.
I have heard far more stories about that than,
When the interstate was built, we got the gravel out of there and then it created this gravel pit, and that's where everybody in high school went and partied.
yeah, for years after, I went down about 9 months after it opened, and for years, every spring, you'd get like remnants of broken bottles or, you know, old rifle shells or whatever, and it was the old part of it.
Yeah, it was. We kidded about that a lot. Behind Howard Johnson's.
So then out of state. Now, Vermont has used some level of out of state housing since the late 1970s when we closed the state penitentiary in Windsor. Some individuals with long-term sentences went out to the feds. We've used it ever since. Now, particularly in the 90s and into the 2000s, it really became a safety valve for overpopulation. And at one point in time, we had 600 people out of state. Now, as a matter of sort of best practice, I don't think you're going to find anybody who would say that best practice is to have a whole bunch of Vermonters serving their time out of state. There may be a few folks for whom that's appropriate, for various reasons. But it started as sort of a safety valve on population. We've never really had enough beds to completely reverse that. I will say those numbers are low. That's the lowest they've been. They've stayed, you know, in that range for quite a while now. we do go down there regularly. I went down there in December of 2022, and probably the most common refrain I heard from folks is, don't bring me back. The guys down there, for the most part, and I cannot say everybody, but for the most part, prefer it. And the reason for that is Vermont facilities have detainers mixed in. So you have a certain amount of instability when you have folks coming in and out. You have folks coming in off the street and they're dysregulated. You have folks getting ready to go out. The guys who are out of state are all serving sentences. The guy who lives in the cell next to me will be there tomorrow. He will be there next week. He will be there next month. Nobody's just coming off the street and all out of sorts because they just got arrested. So there's a calmer sense to it and some more stability. They never see below zero, which seems important today. But yeah, most of the guys, Jordan and I routinely get letters from guys who are in state saying, hey, I just got sentenced. I have a long sentence to do. Can you please prioritize me for shipment to Mississippi? I'm going to do 10 years. I want to do it down there. So we look at that, and if that's appropriate, we'll put them down there. I'd rather send a volunteer, all things being equal, than somebody who doesn't want to go. Anybody who goes down there, we do look at, they need a medical and mental health clearance, which is one of the reasons why housing in Mississippi is cheaper. We don't send folks who have those sort of advanced needs. And make sure their sentence structure is appropriate. They don't have upcoming programming needs. And then we'll put folks down there. But really the intent is if somebody's down there, hopefully they have a period of time to serve and they can be stable at a location.
Oh, we have a question.
I understand there certainly are a litany of public policy questions revolving around whether or not a Vermont inmate is by the Gulf of Mexico.
Maybe the Gulf of America pretty soon.
All right, I'm going to call it the Gulf of Mexico when I get in trouble with anybody. But just from a straight dollars and cents perspective, what is the roughly median differential between individual being in Mississippi for a year and being here in Vermont for a
It's
year?
cheaper. I don't know if you know the numbers.
I think that, again, these are relatively
I understand.
calculations. I think when we did this exercise a year or two ago for Senate Judiciary, anyways, our estimates were 95,000 in state and 40,000 out of state, and then 9,000 for community supervision. Again, a lot of those costs are fixed.
So some of the,
Comparing apples to
I
apples.
was going to say, some of that obviously is labor costs are very different in Mississippi than here. But there is an awful lot of that's not apples to apples. Those folks who need all of the most expensive folks who need smaller units, a higher level of care, need more medical care. Those folks are in state. The processing of folks in and out the door, that happens in state. So there's certainly some labor savings, I'm sure, but there's also the populations are not the same.
Our population that we house here are your ones with the most needs, most medical needs, most aging out needs, end of life needs, mobility needs, mental health needs. And your programming, you're not.
Yeah, we don't do,
There that has programming.
we do the programming up here. If somebody is down there, when they are ready for programming, we bring them back. We also, as folks get older, usually strive to bring folks back. We have had a couple of folks who have asked that we not. They've been out of state for a very long time. My friends are here. There's nothing left for me in Vermont. I know I'm not going anywhere and I'm comfortable staying here. But by and large, we really do like to get folks who are older back in state where we can have a better eye on them.
Does the contract also in Mississippi include the cost of the building? The depreciation of that? I don't believe it
No,
does.
we actually pay a per diem cost.
Yeah.
It's a per diem, but does that include parts of the building in terms?
I don't think so. No, I think it's literally
Costs too.
it's a literal, yeah, we have to pay for the buildings up here.
You gotta pay for the buildings and all.
I mean, I buy something on a de facto basis as part of the building. If I'm selling somebody an oil change, I don't charge them for depreciation on the roof of my facility. That's it.
But it's incorporated in your price for the oil change, yeah.
Yeah.
And I'm sure it's incorporated in their per diem.
Right.
Uh,
Sometimes it has been and sometimes it hasn't been. And that's why I brought that up. Because there's times in the past it wasn't important.
And we have not always been in Mississippi. We've moved around our country a number of times. So.
And there could be 10 hours of discussion just on the topic, and I'm not going to ask you. I just wanted to get a rough idea.
I think the thing to remember, it's not comparing apples to apples. That's the key to remember. On the surface, it looks almost so much cheaper. Why don't we just send them out of state? But when you start looking at the cost of providing the required needs, we're required to provide those. It's under the custody of the state. We are required to provide those services to folks who are under our custody. So I just want folks to remember, you're not comparing apples to apples. On the surface, it looks really attractive, but when it's tried.
Yeah, and we couldn't, it would be very difficult if you said, you know, we want to ship another 200 folks out of state to save money or something like that. I don't, it'd be remarkably difficult for the department to identify more folks that we could move in that sort of volume. I know Jordan and I have done that work along with Rick Burns to look at who can go, and there's just not a huge bulk of folks who have such low needs that they can go.
And if you're trying to put folks with high needs, well, other states accept it.
Or what does our per diem go to? Because folks would charge accordingly.
So that's my question.
James and then, no, James, Kevin, and then.
Not advocating for anything. I'm just curious. So apples to apples. Are there other program states or facilities, private or otherwise, that offer higher levels of programming that we're not paying for now? Like, is it even an option? Is what I'm asking.
So any sort of risk reduction programming, treatment for violent offenders or for sex offenders, I don't know that the department would feel comfortable outsourcing that to another state. Those things really have a direct impact on public safety in a very real way before people walk out the door. And I don't think the department would feel very comfortable without doing that or having really good oversight on that.
Thank you.
We also, the other thing I'll mention is that we are a very, very small bucket in that, which does just add some complications. If I was looking to house 1,000 people somewhere, there's a certain amount of money you're talking where folks will move mountains for you. We're looking to house a very small number of people, and that is limiting.
Kevin, and then Joe.
Who defines the parameters of the individuals that can be sent out to state? Is that state or is that federal or?
No, that's the state. That's under the commissioners. Title 28 gives the commissioner that discretion to set up that.
These are not federal prisons.
Nope.
They're not federal.
They're serving state
They don't go
sentences.
through federal court. They're not serving a federal charge. Those are in state. They're in the state under the custody of our commissioner.
And the commissioner under law has the ability to set out those parameters.
So if Vermont law changes, those parameters could change.
Oh, absolutely. And
Allow more to be
there's been
Mississippi or something.
well, there's been I think bills proposed at various times prohibiting us from doing it at all.
Right.
And we said we don't have enough beds to do that. But I mean, Vermont law could go in a number of different directions that could impact that because it is Vermont that chooses that.
Well, would it be possible to arrange for another hearing germane to the subject with questions such as, how is it determined who goes to, it's Mississippi now, but it could be another place at some point in time?
How to say how,
How many of those people willingly go there? How many people are advised you're assigned to go there? Of the balance of those in state, who would be eligible to go there? And obviously that's a moving number, but I'm sure you could get some sort of determination.
We can, and what I'm thinking for information for that would be, we'd need to know programming needs, we need to know length of sentence.
we have criteria on it.
Schedule them,
Whether or not that's something the committee wants to dig into, it's certainly something that we could share.
do that.
And alternatives, I mean, is Mississippi the only place that,
So
no, it's not.
no, it's not, but
It's not.
they won the contract last time we put it out, the last 2 times we put it out. And actually our relationship with them has been really good. Core Civic has been responsive. During COVID, we essentially handed them our protocol for in-state and said, do this. Initially, they had their own protocol and we weren't thrilled with the results. And so we had developed our own protocol for in-state And we brought it to them and said, this is what we're doing and we need you to do this here. So that we get the same outcome. So they've been good and responsive to work with on some of that.
So let's hurry up and finish this because we do have a whole different topic that folks from JFO are here to talk about. So I want to finish this up and then I would like to take a 5-minute break. So we're running. Okay.
Okay, that's all I have on bed utilization. I was gonna say, but I think you've mostly asked them, but if you have more, and I do have some slides on earn time, but that can always be,
Let's do it really fast.
that's up to you. I was gonna,
Really fast.
it is, it's only a couple of slides, or we could do it another time.
I'll keep my mouth shut. No question.
Okay, so in the late nineties and early 2000s, the state had a variety of good time laws. In 2005, the state revoked all of those and said, you get 10 years, you serve 10 years. From 2005 until 2021, that is what happened. 2021, the state passed a bill, which is 28 VSA subsection 818, that allows for earning 7 days a month off one's minimum and maximum sentence, as long as one does not engage in a major disciplinary violation or a significant furlough violation. As part of that, the department had to create an administrative rule. When you do an administrative rule, you have to do public comment. We get a bunch of public comment, a lot of it from victims saying, that's not what I thought was going to happen. This terrible thing happened to me or to my family. The judge told me this person would be in jail for 10 years. You're now telling me it might be 7. So the legislature went back and they amended the good time bill, April 26th of 2021. That amendment was very specific. First of all, it removed the word good. It is no longer, although everybody colloquially calls it good time, it is no longer good time under law. It is earned time. I don't make those rules. Y'all did. Secondly, there are 8 excluded offenses that do not earn that time. However, those are very specifically, you had to have been serving that on January 1st, 2021. And the legislature's thought was for victims of folks who had been sentenced to those, they didn't know earned time was on the table. When they heard the judge say 10 years, when they told the prosecutor they were okay with 10 years, it meant 10 years. For somebody sentenced today, good time's on the table. Or earned time's on the table. We can all know that. And when you tell the victim, yes, this is a 10-year sentence, but with earned time, this could be 7 years.
Let me clarify that.
Yeah.
This is where it gets.
You said no questions, ma'am.
There's 8 excluded ones.
Yep.
It's only for those folks that were sentenced as of January 1st of 21. Anyone that's sentenced now under those.
There are no excluded offenses. There are excluded sentences. So if you're sentenced to, I can't take 7 days off of life. I can't take 7 days off of life without parole. So there's sentences that are excluded. That's a very small number of people.
For those excluded ones.
Right, but there's no excluded offenses, and that really is about, it is about everybody being aware going in. The prosecutor, the judge who sentences them, the defense attorney, and the victim can all be aware of what this sentence actually means when it happens. The majority of folks earn that time every month. So that is it. I mentioned old rules. That is for folks who were sentenced back before 2005 or who committed their offense back there, they're entitled to credit allowed under law at the time they're committed offense. So we do occasionally have somebody charged with a very old offense, sort of a cold case sort of thing. If they're convicted of that, they're entitled to time under law as it was at the time they committed the offense. We have a big book that says if you were sentenced, if you committed your crime in 2004, this is what the law was at that time. We have to calculate your sentence that way. Where it comes up most commonly is somebody is resentenced on an old offense. They were sentenced on it, they put in a PCR, and now their sentence is being changed. We still have to calculate it under there. So every now and then you'll hear about old.
PCR.
Yeah, through a PCR.
What is a PCR?
Post-conviction relief. And the other thing is, earned time is not discretionary on the department. I don't get to say, you did a really dreadful thing and I'm not giving it to you. If you earn it, you earn it. And the department adds a calculator to it. And so I have sometimes unfortunately had conversations with victims, who are unhappy with that, but that is just the law. It was built in there, and if they earned it on a given month, then we have to credit the time. And I think that might actually be just about it on earned time. I might have had I can make it more complicated, but I won't. No, I talked about all that stuff, actually. It is not available on probation or parole. Earned time is only available if you're incarcerated or on furlough. So, you have to be either incarcerated or on furlough. If you're on parole, there's no earned time under law, and there's none for probation.
We're gonna be getting into earned time too, because there's also a recommend a little bit from the Joint Justice Committee. Because we sent a directive to them to take a look at it to see if we should extend earned time to folks on parole. And also if we should, for folks on parole and possibly furlough, have incentives there if they participate in educational program or vocational program, get a little bit, maybe more earned time, or if it should even exist. And the committee came back and said, hey, there's too many variables here, and to really look at the victim notifications.
I was gonna say, if there was one thing I could throw out there, if you look at that at all, we held those public hearings in the last parole one, and I actually ended up transcribing a lot of that. For whatever reason, that was my role at the time. And I would just say, if you're looking at anything like that, please get victims in here up front, or victims advocacy groups up front, and get that beforehand before you do anything. And, you know, I've worked with some of those folks. There's certainly folks who are happy to speak to you, and where you end up with that, that's a policy decision. It's your guys' decision. But I would just really encourage that you look for that testimony from them before making any of those sorts of determinations.
So we'll get into it. Sure. Anything else? It's been a long afternoon so far.
Thank you for what you do.
Thank you, Josh.
Thank you very much.
My pleasure to be here. Always happy to answer questions. And
So I'd like some follow-up testimony here, particularly on the beds in terms of how the beds are used over and okay, so let's take a quick 5-minute break and come back, and DLC